Now, we invite our President of MMBA, Senior Advocate, Mr. Isaac Mohanlal, to deliver the welcome address.
The chief guest of the day, Honorable Mr. Justice Anand, Venkatesh, the Secretary, Mr. Saravanakumar, the Vice President, Librarian, and other office bearers and Executive Committee members of MMBA, beloved senior advocates, junior members, students, members of the press, ladies and gentlemen, it is a matter of great pleasure to welcome all of you at this pleasant evening to this wonderful academic session. And all of you know that it has been a pleasure always to listen to Honorable Mr. Justice Anand Venkatesh. If I start introducing him, it would be nothing but a redundancy so far you are concerned. He has been a fantastic judge. Apart from that, he's a prolific writer, now a great emerging poet, and a good speaker. You have been probably, most of you might have read the articles which are very frequently published in the newspapers about various subjects. Maybe Walter Scott, he must be so happy to see that his dream being fulfilled. He famously said, that is always the famous quote by Justice Markandeya Kadju. Walter Scott said that a lawyer without history, literature, and philosophy may be a mere mason. If he is endowed with any of these qualities, then he can claim himself as an architect. The distinction between a mason and an architect. And what we witness in Honorable Mr. Justice Anand Venkatesh's career is that he has been a combination of all. All his articles, speeches, and even the poems of the day reveal his bent of mind towards history, literature, and philosophy. Therefore, it's a matter of great pleasure to have him amidst us today to deliver the topic, particularly in the context of we completing 75 years as a republic. Recently, he had written an article which was published, I believe, in the Hindu, that is celebrating 75 years of India's democratic journey. It was a nice piece of article which comprises of all the elements of as a democracy, and particularly with reference to the judiciary. He started writing about Keshavananda Bharati, then all the forthcoming cases up to the section 377 IPC striking down. It was a very beautiful small article, but very beautiful. Today, this is Constitutionalism in the Madras High Court, a journey through 75 years. A nation which the historians of the world and the political scientists across the globe believed that would not survive even for a single year. We have now survived, not only survived, we have successfully lived for more than 75 years, and today, this year, we have been celebrating that. The two credits that we can attribute, one is the beautifully drafted Indian Constitution and the very strong judicial system what we have. As lawyers, we can always raise our collars and say that it is because of the judiciary the Constitution is preserved, and it is because of the Constitution the nation survives beautifully. This is a very phenomenal thing what we have achieved over the years. Now we have reached a stage where we are setting as role models for democracy to the whole of the world. A nation which was never believed to live for 1 year has been living as the role model for the rest of the world for democracy. And it would be very nice to hear Honorable Mr. Justice Anand Venkatesh. And in spite of his very tight schedule, all of you know that he would be sitting even beyond the bell towards the dispensation of justice. Nevertheless, he has chosen to spare time for us. That shows his love and attachment towards us. We, with the very, very warm welcome we extend to your lordships at this evening, and we are immensely pleased because of that. I also extend a very, very warm welcome to each and every one of you present here, and I wish this program a great success. Thank you so much.
Now, we call upon our President of MMBA, Senior Advocate Isaac Mohanlal, to honor our guest, His Lordship Justice N. Anand Venkatesh. Now, we invite our guest, Honorable Mr. Justice N. Anand Venkatesh, to deliver the Republic Day address on the topic Constitutionalism in the Madras High Court, a journey through 75 years.
Thank you for MMBA to invite me to deliver this talk on the constitutionalism in the Madras High Court, a journey through 75 years. I thank the President and the General Secretary and the other office bearers. I also thank the respected senior advocates and beloved junior advocates who have come here after the court time and spare their ears for what I am going to say now. We always start a program with an invocation. For instance, even this program we started with a Tamil Thai Vaalthu invocation. We always invoke it to get that spirit of what we are doing and what we believe. The same way I honestly feel that whenever a program like this based on constitution is done, the preamble of the constitution has to be invoked. For me, the preamble of the constitution is the Bhagavad Gita, the Bible and the Quran for this great country. So, in terms of we being India and we having survived so long and we having managed to be together, flock together and continue to enjoy the freedom in spite of so much of diversity, we owe it only to this book, which is the Constitution of India. So, I'll make one request. Can I request all of you to stand? And I will just start with the preamble. Kindly repeat it. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you. Thank you. Thank you. Every time after I read this preamble, I tend to choke. Meaning I'm not able to, something really, makes me so emotional because it brings to my mind the number of sacrifices that took place, the number of people who gave their life for this, and the time that was spent by stalwarts, the best of brains, to bring this wonderful piece of legislation, which we call as the Constitution of India. And we are what we are after 75 years only because of this Constitution of India. So every time when I go near this preamble, this Constitution of India, It's a very emotional, it's a mixed emotion for me. Sometimes I choke and cry. It's so important for us. I remember the judgment in Sajjan Singh, where for the first time, Justice Mudolkar and Hidayatullah, who were the minority judges in that, they who wrote the minority judgments, dealt with this power of amendment. So they dealt with this power of amendment, and they, till then, and also the majority in the judgment was that the parliament is the supreme and that they can amend and bring in anything, take out anything. Mudolkar says, can you amend and take away everything from the constitution? He says, can you take away the life? Can you take away the liberty? Can you take away whatever has been said in the preamble? And if you take away, what is that is left as a constitution here? He raises that question. And it's quite ironic that he draws inspiration from the judgment of the Pakistan Supreme Court, delivered by a Christian judge named Cornwallis, who comments by placing reliance upon the German, who said that you can amend, but when you amend, don't take away the basic features, or the fundamental features is the word used by Cornwallis. Fundamental features. If you take away the fundamental features, then there is nothing to be called as a constitution. So, I would always think that Sajjan Singh was the most important moment in the history of the evolution of the Indian constitution, because ultimately it came and landed in the judgment in Kesavananda Bharati, which was a wafer thin, not even it's a 7:6, it's a 6.6:6.4. It's that wafer thin. And there are some people who believe in theories, who always say that the court should not have done. But what they have forgotten is that if that was not done at that relevant point of time, we will not be sitting and talking like this. We would have got one other constitution by now. The constitution would not have been alive. So, the judgment in Kesavananda Bharati, when it came, that the starting point for that is this Sajjan Singh case. So, the reason why I am saying is that Mudolkar there will say that your preamble of the constitution, which we the people have given it to ourselves, are the four pillars. And if these four pillars are not there, there is no constitution at all. So he says, if you want to understand the basic features, just look at the preamble. And the preamble provides you with all the basic features that are a must if we are to survive as a nation. So that's the reason why I thought that I will start with this invocation. I believe that the students of law in colleges and advocates, everyone must be made to utter this preamble once in a while, like how we do as Tamil Thai Vazhuthu. I would even say that it's like our national anthem. Why do we do that? We do that to get that energy, to get that feel, to remind ourselves as to what we are today and where we are placed is because of these great people who have given it to us. So I thought we will start with this, and thank you so much for standing up and joining me in that invocation. 26th of November normally used to be celebrated as a law day. It is now celebrated as a Constitution Day. Just a brief history. So by 1947, October 1947, the constitutional advisor, as you all must be knowing, is B.N. Rao. He is the constitutional advisor. He had prepared the first draft of the India's constitution, and with that first draft, Constituent Assembly sat, and they sat for 2 years, 11 months and 17 days. 2 years, 11 months and 17 days. And the first final draft of the constitution took shape on 26/11/1949. 26/11/1949. The initial constitution actually had 243 articles. 243 articles, and it had 13 schedules along with it in the appendix. Then the various eminent people whose names all of you know, these are the, I would say that these are the best of the brains who were available at that point of time. And these outstanding brains of India actually dealt with 7,635 amendments that were moved. It's a mega task. We are now having one constitution with us, but we don't know how much of work has gone into it, how much of contribution has taken place. So therefore, I thought it's my responsibility to place all these things so that the youngsters here will know what they are having in their hand and what is that they are reading from it and what work has gone into it. So there were 7,635 amendments which were moved, out of which 2,473 were either adopted or dismissed or accepted. And finally, we got a constitution which had 395 articles and it had 8 schedules to its appendix. Of course, we have one of the longest constitution, and somebody described our constitution as a 1,46,385 word tom. That's how many criticized. In fact, Jawaharlal Nehru had his own way of looking, and he was also not in favor of such a long constitution. So they called it as 1,46,385 word tom. Sir Ivor Jennings, as all of you must be knowing, he described our constitution as too long, too rigid, too prolix, and said that the dominance of the Constituent Assembly by lawyer politicians, just mark it, by lawyer politicians had contributed to its complexity. This is what Ivor Jennings said. And the joke is this: he was entrusted with the task of drafting constitution for Ceylon, what we call as Sri Lanka, and that constitution lasted only for 14 years. So the criticism which Sir Ivor Jennings had on the constitution, and he thought he was able to come up with a compact constitution for Ceylon, was not even able to last for 14 years. It's very important to take note of what Ambedkar said on this long constitution. Ambedkar justified this long constitution, and he said that we are at a very nascent stage. We are at a very, very beginning stage, and we are going to face lots of challenges, and the country was already under turmoil. As all of you must be knowing, the partition, everything was happening. It was burning. The country was virtually burning. He further said that, this is a very important thing about which there is a lot of misinterpretation. He further said that we don't have constitutional morality as is prevalent in England. This is a word used by Ambedkar. If you please go through the Constituent Assembly debates, this is what he says. So the issue is, what is that he saying? What constitutional morality is he talking about? That's the issue. See, constitutional morality is a term that was coined by Professor Dicey. And as you know, Britain does not have a written constitution. They don't have a written constitution. and they go by just the conventions. And and these conventions are followed from time to time by Britain. Dicey said that starting from 1685 or 1700 onwards, Britain has developed various conventions and constitutional morality. This is what he says. And constitutional morality requires to respect convention, and you don't need a written law, is what he said. So, constitutional morality is not moral immoral as we are trying to understand it. Constitutional morality, as was coined by Dicey in the beginning, was proper following of the conventions from time to time. Once you do it, then it's called as a constitutional morality. And therefore, if you take that as the basis and try to understand what the constitutional morality now is, to follow the constitution in letter and spirit and do what the constitution is asking you to do. And if you do that, and if you comply with the constitution, you can safely call it as constitutional morality. So this is the basis of this term, constitutional morality. Then, so Ambedkar said that what we had was just the Government of India Act 1935 at that point of time. That's the only thing we had, 1935 Act, and we did not have enough time to develop conventions, right? So, in order to avoid any ambiguity, in order to avoid any doubts, he said, let us put everything into writing. Let's put everything in writing in the constitution. So that's how he justified the long constitution. And many who were jocularly commenting upon this bulky constitution never would have envisaged, never would have thought that this bulky constitution is the one which is going to ride India, and it continues to sustain all of us for 75 years. So, the bulk of constitution as it was drafted is based on this Government of India Act 1935. The bulk of it is only the 1935 Act. And of course, as you must be knowing, there were various studies made from other constitutions like US, Ireland, Japan, Germany, etc., etc. And we took those important things from them, and it was all incorporated into the constitution. As Mr. Isaac Mohanlal was saying, that nobody expected that we will survive for such long with the constitution because of the situation that was prevailing. And in any case, 75 years is remarkably a long time. Please appreciate that. Don't take this for granted. 75 years is a remarkably long time. And as he said, no one really believed that our constitution will survive for so long. Consider not only the situation prevailing. India was not India as we are looking at. 562 princely states integrated into India. So nobody knew, because even then, till the last moment, Kashmir and Hyderabad were dragging their feet. So for everybody to get in, 562 princely states to get in and get integrated in India, India as a whole, as we see it, was something which also happened only at that point of time. And we have a constitution at that point of time. So the survival of the country as India itself was doubted. So the first doubt was whether India as it has formed will be able to survive. Then the second question is, will this constitution survive, if at all India survives? So these are the two things. I must also tell you that a research was conducted. This is a study which was conducted by Tom Ginsburg, and he belongs to the Chicago University. So what they did was, they went into all the written constitutions, and starting from 1789 onwards, all the written constitution, they found that the average life of a constitution is only 17 years. They went into all the constitutions. The average life of a constitution is only 17 years. Of course, US Constitution has survived for more than 200 years, and the US Constitution hardly had only 27 amendments to it. Except that any other constitution which they took into consideration from 1789 had survived only for 17 years. Should we not be very proud that we have survived for 75 years with such a bulky constitution? I remember reading somebody saying that life of a written constitution, like the life of law, is not logic or draftsmanship, but it is all experience. It's the experience which ultimately boils down into a written constitution like this. It is comparatively easier to frame a constitution. Meaning, when I say easy, don't take it in the literal sense. I'm on the comparative study now. It's comparatively easy to frame a constitution than to work on that constitution. We are talking about two completely different things altogether. See, in the constitution making, there are many hidden forces. And these are the spirit of persuasion, the spirit of accommodation, and the spirit of tolerance. My dear friends, if we were to do this constitution all over again today, I said that these hidden forces are spirit of persuasion, of accommodation, and tolerance. In a recent article that was written by Gopalakrishna Gandhi in Hindustan Times, he says that in India, as in the rest of the world, all the three are at a very low ebb. All the three are at a very low ebb. So possibly it's not possible at all. So look at how important it was that at that period of time, they had put every experience, they had persuaded each other, they had the tolerance, they put everything, and they have given us this book. And it's impossible to come up with another constitution going forward, because all that has come down considerably. And I cannot elaborate more than that. Then I said that 17 years, right? So we had small neighbors around us. We had Sri Lanka, or we have Sri Lanka, we have Pakistan. Sri Lanka, they have changed their constitution thrice. Then Pakistan has changed it 5 times. Nepal has changed it 6 times. In my opinion, the conscience of this constitution, what is that is the reason as to why, as such a big country with so much of diversity, we did not fall into the trap and we did not get our constitution changed. I think it's part 3, which is the fundamental rights, and part 4, which is the directive principles of state policy. These are the main reasons for the survival of this constitution, is my personal opinion. And let us not forget that it is the interpretation that is given by the constitutional courts, and particularly the Supreme Court, which is the final say, which has the final say under Article 145(3), which is the Constitution bench, as to what interpretation of the Constitution shall be. This was reiterated by the Supreme Court in Puttusamy judgment. As you know, that judgment is in 2017. So the court has actually saved this constitution. The court has actually saved this constitution, and by now, as I said, if not for the Sajjan Singh, which ultimately boiled down, which ultimately reached the greatest of judgments in Keshavananda Bharati, our constitution would have been wiped out. And particularly, if you go through the 42nd Amendment, you will understand what I am saying. And even the life and liberty that was guaranteed under Article 21, it's not something which Constitution gives. Nobody gives. As and when we come into this world, it is guaranteed as such. And therefore, you will find the word used there is any person. And it does not talk about a citizen. It talks about any person. That right is guaranteed under 21. And the 44th Amendment said that you can, whatever you change in the Constitution, you cannot lay your hands on Article 21. So, it's the courts, particularly the constitutional courts and more particularly the Supreme Court, which has ensured from time to time that this Constitution is properly dealt with, properly applied, and this country is able to survive to a large extent because of the Constitutional Court, and we must be proud of it. And finally, one question was asked to Dr. Ambedkar. Because he is the chairman of the drafting committee, the question that was asked is, this was the final debate for which he is giving his reply. And the question is, will this constitution survive? So the same thing was asked. His words, I'll quote. I feel, however good the constitution may be, it is sure to turn out bad because those who are called to work it happen to be a bad lot. However bad a constitution may be, it may turn out to be good if those who are called to work it happen to be a good lot. This is exactly the answer which was given by Dr. Ambedkar. So, the working of the Constitution, he continues, the working of the Constitution does not depend wholly upon the nature of the Constitution. It is therefore futile to pass any judgment upon the Constitution without reference to the part which the people and their parties are likely to play. So that's why I said that comparatively it's easier to make a constitution, but to work on it is the one which really gives us the challenge. So I thought these fundamentals I have to lay before you before getting into this. When they approached me, I thought there are lots of lectures given on the great judgments of Kesavananda Bharati, Minerva Mills, Puttasamy. Many are talking about it, and why would I come and repeat the same thing? So what I thought was, we all are practicing in a court which has seen stalwarts. We are practicing in a court which has seen stalwarts not only in terms of the advocates, in terms of great judges who have sat in our court and have interpreted the law. And I thought we must all feel proud that we are also part of this great institution. And it's Madras High Court which has contributed so much. And let's not again and again get into the issue as to what was done in the Minerva Mills case. It's all important. But the youngsters, the students, the juniors must know that they have stepped into a court which has a great history, which had stalwarts, which had brilliant minds, in terms of judgments and interpretations. And for a very, very, very long time, Supreme Court will always safely lay their hands on Madras High Court judgments. So, let us have that spirit. Let us be proud. Let us have the pride to say that I am practicing in Madras High Court. I am a judge of the Madras High Court. And I don't think that you can have a pride more than saying this. And we must all feel proud to say it. So therefore I thought, that why not look at some offbeat cases? Again, in the Madras High Court, there are Royer Park case, this and that. I thought, let us look at some offbeat cases, because I'm going to address the gathering after 5:36. So once it starts dragging, I know what will happen. So I thought, let me look at offbeat cases, which are important, but about which many are slowly forgetting. So I thought I'll choose some judgments like that and address it before you. I will be just looking at some 12 judgments which I was able to lay my hands, considering the fight that I am having with the time as such. But in any case, I will never, for me what is important is to look at the faces of advocates and be in this crowd. I have always said this, and come what may, I will always prefer this, to be in the midst of advocates, to keep talking with them, to look at their faces. That gives me a lot of energy. So even though it's a fight with time, even though I may have to adjust a lot, all that is worth it. So let me get into one judgment after the other. The first judgment about which I want to talk is Madiyalagan versus Srinivasan. Madiyalagan versus Srinivasan. It's I will give the citation. AR 1973, Madras 371. It's a full bench judgment, right? So this is the period where MGR was coming out of. So whatever judgments I am going to touch today will have a lot of politics. It'll have some famous judges about whom we have our own opinions, etc. So it's going to be interesting. So the first judgment is this Madiyalagan, and Madiyalagan is the period where in October 1972 there was a rift among the members of DMK, and as you all must be knowing, Dr. M.G. Ramachandran left the party and he forms the new party called as AIA DMK, right? So what happens is that this Madiyalagan was the speaker at that time, and he was having his allegiance to AIA DMK. So the two members of the DMK, what they did was they gave a notice for removal of the speaker, and 183 members apart from that individually also gave their letters, signed petition saying that speaker should resign since it deals with the removal of the speaker. And they planted Mr. Srinivasan, who was the deputy speaker, as a speaker. So this is the scenario. Madiyalagan files a writ petition in the Madras High Court. So the writ petition is for a writ of mandamus for a direction to the deputy speaker not to interfere in any manner with my right to continue as a speaker and function as a speaker. So this was the writ that was filed. So there were two questions before the Madras High Court. First question is the scope of Article 212 of the Constitution of India, where a court does not poke its nose on the proceedings which are purely happening within the assembly. So the scope of Article 212 was the first question. And the second is whether a speaker could preside over a session where the motion is for the removal of the speaker. So these are the two issues that were dealt with by the full bench of the Madras High Court. For the petitioner, N.C. Raghavachari appeared, and for the respondent, Deputy Speaker M.K. Nambiar appeared. So these are all the details where you will have to relate yourself, and this case was happening in the fourth court. Just think about, visualize it, have a picture as to what would have happened in that court. The fourth court it was happening N.C. Raghavachari was from this side and M.K. Nambiar was from that side. So this full bench comprised of Veerasamy, Chief Justice, Ram Prasad Rao, V.V. Raghavan J. These are some of the important judges who formed part of this full bench, right? They first took up the scope of Article 212 of the Constitution of India. And while dealing with it, they also went into the parliamentary practice as is prevalent in UK. We always do that. So, insofar as the first question is concerned, they said, I quote, that when the motion for the removal of the speaker was taken up for consideration in the instant case, and when at that moment of time, deputy speaker was put in the office as a substitute for the speaker, and if the deputy speaker thereof conducted the proceedings, resulting in the challenged resolution of the assembly, they are all matters which the assembly has the privilege to deal with and decide upon. They are therefore neither illegal nor unconstitutional, as the accredited parliamentary practice enables the House to decide what it will discuss, how it will settle the disputes, and these are all purely internal affairs over which the court will not exercise its jurisdiction. So that was the interpretation that was given. And while doing it, of course, they took note of a lot of English judgments and the practices in UK. All that is not important. So this is what they said. They said that the assembly decided it. The assembly planted one person as the speaker. How he is going to conduct it, how the manner in which it is going to happen, and who is going to sit as a speaker, these are purely within the four walls of the assembly, and we will not get into it. And that's how they invoked 212 into that. And as I said, that the second issue is whether the speaker, namely Madiyalagan, can sit and decide this motion, for which they said they actually relied upon Article 181(1). And they said that the speaker must be considered to be absent here. Meaning Madiyalagan must be considered to be absent on the for the simple reason that no one can be a judge of his own cause. If tomorrow somebody files a quo warranto against me, saying that he cannot continue as a judge of the Madras High Court, so do I deal with that petition? Same is the case here. Same is the case of the speaker, where the motion is to remove him, and he sits as a speaker in that motion and decides it. So that's the issue, for which the words used by the bench is so beautiful. They said that when the resolution comes up for consideration, there is a deemed vacancy under the provisions of the Constitution, and the speaker, even though he is physically present, is said to be constitutionally absent. Look at the felicity of the judgment. They said the speaker, even though he is physically present, Madiyalagan is physically present, is said to be constitutionally absent and cannot therefore be a presiding officer of the assembly from that moment. This is how they completed that judgment. And this judgment was cited, affirmed by the Supreme Court in the case of Nabam Rebia case versus Deputy Speaker Arunachal Pradesh, 2016, 8 SEC, page 1. So, I don't know how many of you know this case. And this is an offbeat case on the privileges of the assembly and on this issue. So, they interpreted three articles. One article is Article 212, other is Article 188, 181(1) and Article 182, subclause 2. So, you can go through it. So, here I don't want to take a class. I only want to tell you look at how beautifully they construed it, and The wordings, I have only told you some 2-3 lines. It's like literature. The judgment is virtually like a literature, and it's so beautifully written. The felicity. So the next case is even more interesting, because this case had Govind Swaminathan. So this case is called as, in the matter of Mr. Hales, Hayles. This is reported in AAR 1955 Madras, page 1. What happened was, there was a provision under section 7(1) of the Industrial Disputes Act where the government can appoint a High Court judge to exercise the function of an industrial tribunal. So he will function as an industrial tribunal, and such powers can be converted by the state government. So that was provided under section 7(1) of the ID Act at that point of time. And what happened was that Justice Mack, M-A-C-K, Justice Mack was a sitting judge of the Madras High Court. He was appointed as an industrial tribunal under this provision to decide the disputes, and the disputes concerns the amalgamation group, which you will find in Mount Road. If you go that side, you will find amalgamation group. And next to that amalgamation group, you will also find, or you were seeing, there was a famous newspaper called as the Mail. So what happened was, after he called the parties, decided and passed the award, this Hales, belonging to Mail, wrote a stinker about this award that was passed by Mack. So Mack issued notice of contempt to Hales, and Govind Swaminathan appeared for this Hale. And when he went before Justice Mack, Govind Swaminathan said, "I will not argue before you." And he said, "You are a functus officio." Will any advocate say that looking at a judge today? Look at the authority they had. Look at the conviction they had. Mack was known for it. And Govind Swaminathan goes and says, "Sorry, my lord, I will not argue before you, because you have become a functus officio." Then Mack issues contempt notice against Govind Swaminathan. So now two people are into the contempt jurisdiction, and the matter ultimately comes up before a full bench. And this full bench had Rajagopalan, Balakrishna Iyer, Rajagopala Iyengar, etc., etc. Such a beautiful judgment. They said that when a judge of a high court is appointed as a tribunal under the Industrial Disputes Act, the question is, has he all the powers of a high court to punish persons for contempt under Article 215 of the Constitution of India? All of you must be aware that Article 215 is the one which says that High Court is a court of record. So when as a High Court judge I exercise my function as an industrial tribunal, do I retain my position as a High Court judge, and consequently can I exercise my power under Article 215? This is the sum and substance of the dispute before the court. The full bench said, equally the full bench was also so neutral, did not look at it as if it was an affront on a judge, as was the case of Govind Swaminathan. Govind Swaminathan was not trying to insult Mack, but Govind Swaminathan was on an issue of law. He said, "You are a functus officio, I will not do it." Because Govind Swaminathan thought that Mack was functioning as an industrial tribunal and not as a high court judge. And he strongly thought that as an industrial tribunal, you didn't have the power. And in any case, you have already passed the award. For me, insofar as that issue is concerned, you are no longer there. This is what Govind Swaminathan is saying. Now see what the full bench says. The full bench says that the proceedings before the learned judge who constituted the industrial tribunal were not proceedings of the High Court, and a High Court of which he was no doubt a judge. This is the wording. They say, the proceedings before the learned judge who constituted the industrial tribunal were not proceedings of the High Court, of which he was no doubt a judge. Any contempt committed in relation to such proceeding would certainly be a contempt of that industrial tribunal. True, it would also be in contempt of the learned judge who was presiding over the tribunal. But nonetheless, it is only contempt of the tribunal and not contempt of the High Court. And the question was answered holding that when a judge of the High Court is appointed as an industrial tribunal under the Industrial Disputes Act, he has no powers of a judge of that court to punish for contempt under Article 250. Of course, this 7-1 was repealed in 1964. We were saved. So, this is the neutrality that is shown. This is how the judges, this is how the advocates were. Where they didn't care whether it is Mac or anyone. They were on the issue before them and they were trying to look at things purely from the angle of law. In fact, once Mac seems to have commented that when I sit in the other room, I am not a High Court judge. But when I am sitting in the adjacent room, I become a High Court judge. I don't understand this logic is what Mac was lamenting later. Anyway, so this is the next one. The next judgment into which I want to go into is again a very, very interesting judgment. This judgment is called as Saka Venkata Rao versus Election Commission. This is 1952 SCC Online Madras, page 367. See, what happens is that this Saka was an MLA and this MLA was convicted for a criminal case and he was inside the jail. That's all. I'm making everything very, very simple. I'm not getting into too much of what Ivor Jennings says prolix. I'm trying to shorten it as much as possible. So he was convicted. He was convicted. He was a sitting MLA, but he was convicted. And what happened was the petitioner, namely Saka Venkata Rao, files a writ petition. He files a writ petition against the Election Commission and he says, directing the Election Commission to forbear from holding the proceedings on the reference that was made to them by the Governor of Madras under Article 192. So what happened was that since he was convicted, he suffered disqualification. And since he suffered disqualification, the governor had notified it to the Election Commission. And the Election Commission was about to act upon it. Therefore, he files a writ petition for a mandamus directing Election Commission to forbear from doing that. That's the sum and substance. The great Subba Rao was a single judge at that point of time of the Madras High Court. And he comes up, the question is whether the High Court exercising its jurisdiction under Article 226 of the Constitution of India has extraterritorial jurisdiction. Whether it can prevent the Election Commission sitting in Delhi from performing a function. That's the sum and substance of the issue. It was such a beautiful judgment of Subba Rao. Subba Rao brings in the concept of cause of action from CPC. Till then, nobody had done that. For the first time, Subba Rao does it. And Subba Rao says that the cause of action has arisen here only. Because the MLA is here, he has been convicted. It's the governor here who is seeking for his disqualification. And ultimately, the decision maker alone is sitting in Delhi. Therefore, a part of cause of action has arisen and therefore he holds that the writ petition is maintainable. And this goes on an appeal. And no less than a person of Patanjali Shastri's status, CJ, he reverses that judgment. Patanjali Shastri says that the rule of cause of action attracts jurisdiction in suits, and it is based on statutory enactment, and it cannot apply to writs issued under Article 226, which makes no reference to any cause of action or where it arises, but insists the presence of a person or authority within the territories in relation to which the High Court exercises its jurisdiction. So, the view of Subba Rao was reversed by the Supreme Court. But what happened thereafter is very important. Then comes the Constitutional Amendment, which upholds the view of Subba Rao. And that Constitutional Amendment is the 15th Amendment, which was brought in 1963. And later, it was renumbered as Clause 2 under Article 226.2. So, whenever you look at Article 226.2, you must be reminded of Saka Venkata Rao, Subba Rao, Patanjali Shastri. So, this Article 226.2 has this history, and I don't know how many knows that it all emanated from Madras. That's why I am saying it's very, 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 very important for us to look at our own history and see what all we have done and how ultimately the judgments of the Madras High Court has been followed and upheld. And here, even though the Supreme Court did not follow it, but the Parliament thought it fit to follow it, and they brought in Article 226.2. So that is the greatness of this judgment. And the next one, of course, I cannot avoid this. The next one is Champakam Durai Rajan. Champakam Durai Rajan. Again, Champakam Durai Rajan was a state is AR 1950 Madras 120. This is a milestone which ultimately resulted in the social justice about which we are talking today. The social justice about which everyone in the state is talking is because of what happened after this judgment was given. So in Champakam Durai Rajan, what happened was the state of Madras at that point of time, it issued a communal GO, and they reserved seats in medical colleges run by the government, and on the strength of this GO, 350 medical seats were to be 350 were to be filled up on the basis of allocation which was based on communal grounds. So this is that government order. One Mrs. Champakam Durai Rajan and one Srinivasan, and these are the MBBS aspirants. They are the aspirants to join this. They challenged this GO. This GO was put to challenge. And they raised a contention that the communal government order was void under Article 15.1 and read with Article 29 within bracket 2 of the Constitution of India. This is the sum and substance of their challenge. They said that your communal GO is violating 15.1 and 29.2 because, as you all must be knowing, 29.2 applied to educational institutions where you cannot discriminate, etc. No less than a person of the stature of Alladi Krishnasamy Iyer appeared for the petitioners. And all of you must be knowing that he was a member of the drafting committee itself. Alladi Krishnasamy Iyer was a member of the drafting committee who drafted the Constitution of India. So he raised this contention that fundamental rights of the petitioners as citizens will be violated if the state is discriminating them on the grounds of religion, caste, community, etc. This was the sum and substance. And therefore, he said it is hit by Article 15.1. The next ground that he raised was, on account of this classification, they will be denied admission only because of their caste, which in turn is hit by Article 29.2. This is the sum and substance of the submissions. This case was heard by, just visualize this bench. This case was heard by Chief Justice Rajamannar, Vishwanatha Sastry, Somasundaram. These are the stalwarts who were hearing this case. It was a unanimous verdict where they said that the communal GO is in violation of 15.1 and Article 29(2), that's not very important. What is very important is that this is the judgment where the classification test under Article 14 emanated. That's why this is very important. And the classification test in 1950, how do you look at, how do you interpret, how do you understand the term equality under Article 14? Was structured only in this judgment, and what has happened thereafter till now is only building upon it. The classification test was actually done in this. So I thought that even though you may be knowing Champakam Rajan, but I do not know how many know that the classification test under Article 14 was actually from this judgment of Champakam Rajan. So therefore this is the first judgment which became a classification, which came out with the classification test, and it's the felicity. It's a big paragraph which I don't want to read at 6:20. It's a felicity of language where they say that inequality or people at different levels is a reality. So therefore, you cannot, where they say it's a matter of common sense that you cannot treat an adult and a child in the same way. You cannot treat a sane man and an idiot in the same way. You cannot treat a millionaire and a pauper in the same. The felicity, as I was reading it, it is so exciting to read this order. And you cannot deal with an innocent and a convicted man equally. See, look at the difference they are bringing in. It is stark differences. So having said all that, they said that this power to govern men and things is inherent in every state, and it involves classification, differentiation, and abridgment of an individual freedom. Obviously, when such classification results in giving some priority to the other person, it obviously results in the other person getting his right getting abridged. So, and they said that ultimately these words, just mark these words only. But the classification or differentiation of citizens in the exercise of this power must always rest upon some difference which bears a reasonable and just relation to the act in respect of which the classification is proposed. Intelligible differentia is what ultimately they said. This was the one which brought out that word. The object sought to be achieved, the intelligible differentia, was how it was interpreted or coined later. But my dear friends, it was the Madras High Court which said that. It was from here it went. It was from here it went. Let us be proud of it. Every one of it, I am saying, people think that it has come from somewhere else. It has all come from our court. It has all come from Madras High Court. And understanding Article 14 is, we must feel proud that it has come from here only. And how you understand this classification test. And this is how he writes it. So what happens is, it was quashed. It was upheld by the Supreme Court. That is year 1951 Supreme Court 226. This classification test was taken, and ultimately in Anwar Ali Sarkar, which is one of the landmarks, they followed it in year 1952 Supreme Court, page 75. So what happens is that since the appeal was dismissed, the judgment of the High Court was confirmed, comes the first amendment to the Constitution. The first amendment to the Constitution is again because of us. It is again because of us. It is again because of the GO passed by the state. It is again because of the judgment of this court, and Article 15(4) was inserted into the Constitution. And because of that, 29(2) virtually was overridden. Because notwithstanding anything contained in 29(2), 15(4) will operate. So this paved way to reservation to the socially and economically backward classes, scheduled caste, scheduled tribe, in educational institutions. And who is the pioneer? The pioneer is the Madras High Court. The pioneer is the Tamil Nadu state which brought this. And today in India, if persons belonging to such marginalized classes are also coming up in life, it is the Madras High Court, it is the Tamil Nadu state which has showed the light to all of them. So we must be proud of it. The next judgment is very interesting. It relates to Mohan Kumaramangalam. So I am sure that most of you in this group will remember this name, Mohan Kumaramangalam. So this Mohan Kumaramangalam versus State of Madras. This is reported in AR 1951 Madras 583. I am sure that some junior is noting down this. So with that fond hope I am saying this. So AR 1951 Madras 583. This judgment was by Govinda Menon and Bashir Ahmad Saeed. What happened was Mohan Kumaramangalam and his wife travelled to Bombay. And at Bombay, Mohan Kumaramangalam was arrested. He was arrested on 24th of June 1950. This arrest was because the Madras government at that point of time said that he is a communist. Communists were treated to be criminals, terrorists at that point of time. So they said that the Madras government informed the Bombay government that a top-ranking communist belonging to Madras is in Bombay and therefore he has to be detained. Bombay government passes a detention order. Understand this. There was a information from Madras to Bombay and Madras said we are looking for this Mohan Kumaramangalam. He is in Bombay. Bombay government passes a detention order. Mohan Kumaramangalam is detained and then Bombay said what is that you have? Just send him to Madras. So Mohan Kumaramangalam is sent to Madras and he is confined in Vellore jail. He is confined in Vellore jail. The next comical thing is Bombay government revokes the detention order. Bombay government revokes the detention order, but Mohan Kumaramangalam continues to be inside jail. That is the time when a writ of habeas corpus was filed. A writ of habeas corpus was filed and again it was argued by none other than our Nambiar. So the writ of habeas corpus was filed and the situation was there was a detention order by Bombay. Mohan Kumaramangalam was arrested, sent to Madras, confined in jail. Detention order was revoked by the Bombay government. That is the scenario. So the continuation of Mr. Mohan Kumaramangalam inside the jail was in question. Obviously, it's a illegal detention. Therefore, a habeas corpus writ petition was filed. So that's a judgment where M.K. Nambiar for the first time argues about the federal structure of the Constitution. The federal structure of the Constitution and whether this extraterritorial power is available to an executive over and above the territory of their state. This is the issue. This is the issue and this issue never came up before. So what he said was, it is impermissible for the Bombay police to arrest a man who was found within the territorial limits of Bombay for his alleged activities in Madras. You understand? His activities as a communist man was in Madras. But whereas the detention order is passed by Bombay and he is detained in Bombay. See, the division bench they said that the exercise of the executive power, as you all must be knowing, is Article 162 of the Constitution of India. It cannot have extraterritorial jurisdiction. That is number one. They said that since the Bombay government had this is how they finished that judgment. They say, since the Bombay government had cancelled the order of detention passed on the petitioner, the proper procedure to be followed should have been for the Madras government to have released him, because there was no basis to continue his detention here. And if the Madras government considered that he should be detained in the state of Madras, a fresh order of detention should have been served on him, which has not been done. Therefore, they found that the detention was bad. And as I said, Article 245 was gone into. the federal structure I said, which was argued by Nambiar, 245, that article itself postulates that the power of the state cannot operate extraterritorially, and this principle was recognized by the Constitution bench in Chamar Bargwala case, which is in AR 1957 Supreme Court 699. It's a Constitution bench, and thanks for the Madras High Court, which was again followed. Are we not feeling proud about what is happening? Meaning, I was so excited when I was collecting it, I did not sleep yesterday night. It was like, boss, I am in a place of this much of judicial activism that had taken place, of this much of evolution that has taken to the Constitution, and who is talking about it? So I said, I will talk about it. I will start this. And this will be followed up with many who will be inspired, and they will go and make research of the other things which came out of this great place. Let us feel proud of it. So the next judgment is even more interesting. That is a judgment of Anand and Nambiar, which is reported in AR 1952 Madras 117. This Anand and Nambiar was a communist. Every problem during that period will come only to the communist, right? So this Anand and Nambiar was a communist, and what happened was that he was detained. He was detained under the preventive detention law, as was prevalent, as was available in Madras at that point of time. And he was also a MLA. He was also a member of Legislative Assembly. So he was inside jail. He files a habeas corpus petition. And my dear friends, this case is argued by Mohan Kumar Mangalam. See how interesting this is. This case is argued by Mohan Kumar Mangalam for this Anand and Nambiar. So the issue is this. The issue is, he says that I am an MLA. The assembly is going on. I have every right to attend the assembly, and therefore send me with an escort to the assembly, is what he is saying. So he is detained, MLA, assembly is going on. He says, as a member of the Legislative Assembly, I have every right to attend the assembly. Send me with an escort, is what he is saying. So Mohan Kumar Mangalam appears for him, and the judgment was by Mac, about whom I said initially, is by Mac and Somasundaram, this judgment. So this Mac and Somasundaram says that first finding is, he is not entitled to ask that he will be taken with an escort, with an armed escort, to attend the session of the legislature. That is not possible, is what they say. But how do you balance his right to be a part of the proceedings that is happening in the assembly? Because that is something which is guaranteed under Article 194(3). 194(3), wherever there is no law in India, where the state or where the parliament is supposed to, then we have to follow the conventions of England. In England, you have the right to participate in the proceedings. There is no law here. So therefore, that convention has to be followed because it is something guaranteed under 194(3). So therefore, they said that he has a right to make representation of his views to the speaker and the chairman of the committee of the privileges, and that correspondence which he makes, his views which he sends, nobody has the right to stop it. And so this privilege was explained, this privilege under 194(3) was explained, and this is so beautiful. I'll just read it. Please bear with me. We hold that during the period of his detention, a detainee who continues to be a member of the Legislative Assembly has a right to correspond with the House. This right, as it appears to us, flows not merely from the principles of natural justice, which will be violated by such letters being withheld, but as a continuing member of the House, he would also appear to be entitled to this privilege under Article 194(3) of the Constitution, under which English parliamentary practice has to be followed until a law is enacted by the legislature defining the powers, privileges and immunities of the House, its committees and its members. So this is one other very, very interesting judgment, where again you will find the characters about whom we spoke earlier, Mac, Mohanlal, they all come into the picture now, right? The next very interesting thing is the judgment in Haja Sharif. This is, I had a hearty laugh after reading this. This Haja Sharif versus Government of Tamil Nadu is AR 1985 Madras, page 55. What happens is, Haja Sharif was elected as a MLA from Thiruvallikeni assembly seat. That is in May 1980. And he was appointed as a honorary counsel of Turkey at Madras. He was appointed as a honorary counsel general of Turkey in Madras. At that time we call it as Madras only. Madras. This is after the approval given by the government of India, and as you must be knowing that he was also the leader of the Congress I party in the Legislative Assembly. A petition was filed before the Election Commission to declare that the petitioner has incurred a disqualification under Article 192 by virtue of him having accepted the office of Counsel General. And this commission, this was accepted by the Election Commission, and the governor passed the impugn notification saying that you are disqualified. See what all has happened. All these things are not happening at all now. Now it's all fight only. See the interesting things which had happened during that point. So governor disqualifies him. That notification becomes a subject matter of challenge. It comes up before a full bench. That full bench had KBN Singh, who was the Chief Justice, then Padmanabhan, Satyadev, etc., etc. Satyadev was there in that bench. They said that you having accepted the office of the honorary counsel, you have associated your allegiance to a foreign state. Irrespective of whether you are playing a role or not, you have invited a disqualification. The words that they use, the reason why I died was, why I died laughing was, it may be that at the inception of appointment, like a probationer, not being entrusted with full responsibilities, only limited functions might have been assigned to him. It's a kindle adikirathu and then writing an order, like a probationer. But by virtue of the said appointment, what all he could discharge will have to be taken into account. Not what he is actually doing. What all he can do must be taken into consideration. The constitutional disqualification would not depend upon the extent of commissions or omissions done by that incumbent. In fact, this is the most important thing. He was directed to see what he has done after taking up that position. He was directed to take custody of 3 Turkish flags. 3 Turkish flags were handed over to him. 1 small Turkish flag for his car. 1 Indian flag. 2 seals, 1 Indian flag, 2 national anthem tapes, 1 national anthem record from the brother-in-law of the previous honorary counsel at Madras. These were the things. He was disqualified. They said the guidelines state that for all disputes. So this judgment was very, very interesting in terms of what would happen when he thought that he is going to become the Counsel General of Turkey, and suddenly what made him that was taken away from him. So this disqualification was upheld, and if you have the time, read Article 199 small d. I am not getting too much into the provisions because it will take a lot of time. 191 small d of the Constitution of India, you will find that it is a disqualification. Once your allegiance is to a foreign country by holding the position of a Counsel General of Turkey. So they said that you can no more continue to hold the position as a MLA here. The Next important judgment is M. Karunanidhi versus Union of India. Since I spoke about MGR, I thought I cannot stop without talking with M. Karunanidhi. So this judgment is AR 1977 Madras 310. As you must be knowing, the Chief Secretary of the Government of Tamil Nadu made a request to the CBI to investigate a case of corruption against the former Chief Minister, and there were various allegations, and therefore an FIR came to be registered against Mr. M. Karunanidhi. And what happened was, investigation was completed, sanction was given, police report was filed for offence under the Prevention of Corruption Act and IPC offences, right? So these were the offences for which at that point of time there was an act called as Tamil Nadu Public Men Criminal Misconduct Act 1973, and this was traceable to the concurrent list. This was traceable to the concurrent list, and the state had received the assent of the president also, which means, as you must be knowing the fundamentals of the constitution, once you get the assent, it will prevail over the central law governing that. Once you get the assent, right? It's like the criminal procedure code. Criminal procedure code is a central law. For the benefit of the youngsters here, criminal procedure code is a central law, and in the criminal procedure code it is traceable to the concurrent list, and if the state wants to make amendments, it can make amendments, but that amendment must get the assent of the president, and once that assent is given, the provision to that extent will overweigh the provision that has been provided by the center. So this is how it acts, right? Just for the benefit of the youngsters here. So therefore, the point he takes, and you must understand that Mr. K.K. Venugopal appeared for Karunanidhi in that case. So the point that they took was that he can be prosecuted only under that 1973 Act, whatever I said, which had received the assent of the president, and the State Act had contained provisions which are repugnant. The theory of repugnancy was dealt with in detail in this judgment, and they said that to that extent the provisions of the Central Act, which are the Central Acts, the Indian Penal Code and the Prevention of Corruption Act, to that extent it says that it is repugnant, and therefore in view of Article 354(2), the State Act alone will prevail, and you cannot try me under IPC and Prevention of Corruption Act. This is the point taken by him. Ultimately, the bench concludes by saying that IPC and Prevention of Corruption Act is not traceable to the concurrent list. It's a pure and simple central legislation, and you are tracing the right under the Act, 1973 Act, from a concurrent list. That cannot overweigh a central enactment. That is number one. Number two, while committing an offence, it can be an offence in a state act. It can also be an offence under the central act. For instance, TANPID. For instance, there is an offence under the TANPID Act. It can also be an offence under IPC. You cannot say once it is an offence under the TANPID Act, it will overweigh everything, and so it's a state act. It's a central act. So they said, ultimately what they held was that it's an enabling provision. What is important in this is, they speak about the law of repugnancy, and the beauty of this judgment is two types of repugnancy they are talking about. One is provision specific repugnancy, and the other is called enactment specific repugnancy. Beautiful, just beautiful. I don't know, we are not exposed to all these things at all because of the volume of work which we are doing. These are some beautiful things to which we are not exposed. They speak about these two types of repugnancy in this. One is provision specific repugnancy, which means considering a particular provision. For instance, 438 of CRPC talks about anticipatory bail. In Allahabad, they brought in a state amendment. Through that state amendment, 438 was repealed. It also got the assent of the president. So it's a repugnancy, which is a provision-specific repugnancy. Here, what was argued was an enactment-specific repugnancy. They said because of the 1973 Act, you cannot invoke the IPC and the Prevention of Corruption Act, is what they said. But of course, it was not accepted. What happened was it went to the Supreme Court. By then, MGR became the Chief Minister. So what he did was, straight away he repealed that 1973 Act. So by the time it was heard by the Supreme Court, the 1973 Act was not available. 73 Act was not available. And this judgment of the full bench was on 10/5/1977. It was repealed. But in spite of it, Supreme Court went into the issue for the simple reason that it dealt with the repugnancy principle. So this decision of you must remember, just as a passing remark, you must remember that section 21 of IPC as to whether the chief minister can be brought within the term person, public servant, was dealt with, and therefore I don't want to get into that issue now. But what is important, since we are talking about constitution, I thought repugnancy can be the focus of this. So it's such a beautiful judgment. And the next one is V.G. Rao versus Alagiri Sami. This is a judgment in AR 1967, Madras 347. You must be knowing Justice Alagiri Sami. Alagiri Sami used to be Kamarajar man, basically. So he was always only in the government departments. He came, if I am right, he came up to the position of a law secretary there. He was always there. And the great Kamarajar somehow wanted to make him a High Court judge. So what happens is, in 1959, he is first made as a government pleader. 1959. That appointment itself is challenged, saying that this man has never come near the court. And he is now being made as a government pleader. But the court, the division bench dismissed it, saying that it is for the government to choose their advocate. You cannot say the man who practiced only can come. It is for the government to choose who will represent them in the court. So therefore, that was gone. After having come, for 6 years, he was a government pleader. And 1967 elections were coming. 1966, 8/8/1966, he was appointed as an additional judge of the High Court. So this is how Alagiri Sami was appointed. At that point of time, V.G. Rao, the great Rao and Reddy, he files a writ of quo warranto, and he says that this judge does not possess the necessary qualification as prescribed under Article 217(2)(b). 217(2)(b), as all of you must be knowing, is 10 years in the High Court. So this is the position. And who appears for him? Vasanta Pai. The fiery Vasanta. We all had the opportunity of looking at this man, Vasanta Pai. Vasanta Pai appeared, and he told the court that he must be a practicing advocate in the court, and he must not merely be a person who is enrolled in the rolls of the High Court, is the ground that he raised. So he said that the expression advocate of the High Court, as found in Article 217, should be read as an advocate who has continuously practiced in the High Court for 10 years. This is the interpretation based on which the quo warranto was filed. The court interpreted it. It was the judgment penned by Srinivasan J, not our Srinivasan, the other Srinivasan J. And he said that the makers of the constitution did not insist for something like that. And he said that, to my mind, It's enough if you have an advocate, if you are an advocate who was having the qualification to practice in the High Court, and there may be advocates who may not be having so many cases in the High Court and they may be practicing elsewhere. And therefore, don't try to bring in this test that the practicing advocate must be an advocate of a High Court for 10 years. So, what is the moral of the story? The moral of the story is that many persons who do not practice in High Court become High Court judges. So that is the moral of the story. And it actually started, surprisingly, it has all started from Veerasamy, about which I didn't know till I read this. So this judgment was, thereafter he was elevated to the Supreme Court also. Then this judgment was interpreted when our own Navanitha Krishnan was made as an Advocate General. So, he was made as an Advocate General during the regime of former Chief Minister Jayalalitha. So, the same issue was raised because Article 165 of the Constitution is in pari materia too, because the qualification of High Court judge is the qualification of. So, therefore, they raised the same 10 years. Justice Basha and Justice Paul Vasantakumar sat in the division bench and they took cue from this judgment and upheld the appointment of Navanitha Krishnan as the Advocate General. And the one other very important judgment, because I think by 7 I will finish it off, if you don't mind. If you think that I'll have to finish, I'll finish it off. The one other judgment which is very, very interesting is this tribunalization. All of us are thinking that Madras Bar Association MBA case is the first case for tribunalization. No. Actually, we are wrong. First Chandrakumar is on the interpretation of 226. As against tribunalization and having administrative members forming the majority. The judgment is V. Balachandran versus Union of India. That is the judgment in 1992, One Law Weekly, page 396. And that case was heard by Justice P.S. Mishra and Swamidurai. We have all seen P.S. Mishra here. So, and Swamidurai. And this was a case where they brought in some rules whereby the selection board will comprise only of secretary to government. Only secretary to government. And it will be, so if they are the selection board, then obviously the company law board will contain only administrative members. That was put to challenge, and that is where our Arvind Dattar gets in. For the first time in this case. Mr. Arvind Dattar, senior advocate, is the one who is spearheading this anti-tribunalization till date. And this is the first case actually. The MBA case is the second case. MBA has trilogy. There are 2-3 MBA cases thereafter. And this fight of tribunalization, etc. is going on and on. This is the first starting point of the challenge to such tribunalization. And this judgment was penned by Justice P.S. Mishra. And he basically says that instead of weighted in favor of administrative members of the tribunal, it should be weighted in favor of judicial members, and the chairman should be none but one who is qualified to be a judge of a High Court or has been a judge of a High Court. So basically he said that you cannot have a constitution of the selection committee like this and make it a fiat accompli where you will only have administrative members and you will never have a judicial member at all. And he said that such tribunalization can never be countenanced, can never be accepted. So this is the reason why I quoted this, is because this is the precursor for the first MBA judgment in 2010 11 SEC page 87. This is the one, because 2010 there was a fight, 2014 there was a fight, it continues. But this is the precursor. So therefore I thought that this is one important judgment about which I'll have to talk about. And The other important judgment is Charan Singh judgment. What happened was that, I'll quickly go through this. This is in 1979, where from Madras, this is the beauty of it. Janata government was losing the majority there, and what happened is that the leader of opposition on 9th July 1979 was I think YB Chavan. So YB Chavan was the leader of opposition. He gives a notice of a motion of no confidence against the government, right? So the government was headed by Morarji Desai, Janata Party. And it came to light that he will not be able to sustain. So Morarji Desai tenders his resignation. Then the president calls YB Chavan to prove his majority. And YB Chavan also declines it, saying that I cannot prove the majority. Then comes this. Then he calls Charan Singh. Charan Singh is called, and on 26th July, Charan Singh was asked to form a government, and he also becomes the Prime Minister. And what happens is that when the vote of confidence came, he knew that it was not possible to prove the majority, and therefore he says that I will not be able to prove it. The parliament is dissolved, and Charan Singh is made as a stopgap Prime Minister. He was made as a caretaker Prime Minister. Caretaker Prime Minister. Do you know who challenged it? Cho Ramasamy in Madras High Court challenged it. The judgment is yes, Ramasamy versus Charan Singh. And Ramasamy versus Charan Singh. And this is a very interesting judgment, because this question is, once it is dissolved, can you appoint a caretaker Prime Minister? The long and short of the issue is only that. So they go into the entire thing, and they ultimately, please see what they are saying. They are saying Article 75.3 is the most relevant thing, because that's the Council of Ministers. 75.3 does not apply when the House of the People stands dissolved. The Lok Sabha was dissolved on 22nd August 1979, and therefore Article 75.3 can have no practical application, with the consequence that the continuation of Sri Charan Singh as the Prime Minister of a caretaker government from 22nd of August cannot be characterized as illegal. And he says the President can allow Charan Singh to be the Prime Minister or somebody else to be the Prime Minister, because it's only a caretaker government. So this is a very interesting judgment, because nobody in Delhi challenged it. Somebody in Madras challenged it, and this case was argued in the Madras High Court, and it was Ram Prasad Rao who was the CJ at that point of time. The bench was Ram Prasad Rao, Ismail, Ramanujam, V. Ramasamy, Sethuraman, Mohan, and Nainar Sundaram. 7 பேர். So unless somebody tells you, you may not know that this has happened in the Madras High Court. And finally, the judgment in Tamil Selvan. The reason why I chose Tamil Selvan was because it involved our own G.R. Swaminathan. It involved our own Hon'ble Justice G.R. Swaminathan, because he was the one who was standing by Perumal Murugan. And it was penned so beautifully by our own Justice Sanjay Kishan Kaul. And the other judge who was sitting was Pushpa Satyanarayana in that bench. So this was such a beautiful judgment, I would say. It was a precursor for the freedom of expression of a writer. Meaning it showed what the character of Justice Kaul he was inside in terms of freedom of expression. And the way in which he had completed the judgment was just fantastic. He would say, let the author be resurrected to what he is best at, dash, right, W-R-I-T, right. So this judgment ultimately was followed by the Supreme Court in Indemnity Creative Private Limited was the state of Bengal. That is 2020, 12 SEC page 436. So there are 2 or 3 other judgments, but I don't want to do it because the clock is at 7. So I thought that it's worth taking this effort. It's worth spending my time to dig and find out what is there and what has been contributed by this great institution towards the evolution of the Constitution of India, and how we are pioneers in a lot of important things that are now picked up by others. So thank you so much for the opportunity. Thank you.
Thank you for that riveting speech, Your Lordship. Not only did you invoke the spirit of the Constitution, you also transported us through 75 years of the constitutionalism of this great High Court of Madras. Thank you once again. Now we call upon our General Secretary of MMBA, Mr. M. Saravanakumar, to deliver the vote of thanks.
நண்பர்கள் அனைவருக்கும் வணக்கம். இந்த நிகழ்வுக்கு ஏற்பாடு செய்த நமது தலைவர் அவர்களுக்கும் 75 நிமிடத்தில் 75 வருட வாழ்க்கையை மிகவும் அழகாக நமக்கு எடுத்துரைத்த நீதியரசர். சுருக்கமாக சொன்னால், எப்போதெல்லாம் அநீதி துவக்கப்படுகிறதோ அப்போதெல்லாம் நீதி தேவதையால் அனுப்பப்பட்ட ஒரு நீதியரசராகத்தான் நாம் பார்க்க வேண்டியிருக்கு. அந்த நீதியரசருக்கு நமது சங்கத்தின் சார்பாக மனமார்ந்த நன்றிகளையும் வாழ்த்துக்களையும் தெரிவித்துக் கொள்கிறேன். விழாவிற்கு வருகை தந்து சிறப்பித்த மூத்த வழக்கறிஞர் வெங்கட்ரமணா சார் அவர்களுக்கும், கிருஷ்ணவேணி மேடம் அவர்களுக்கும், சகோதரர் காந்தி அவர்களுக்கும், நண்பர்கள் அனைவருக்கும் சங்கத்தின் சார்பாக நன்றிகளை தெரிவித்துக் கொண்டு நன்றி கூறுகிறேன். நன்றி.